Well, we talk a little bit more about this with legal expert, Advocate Molatelo Mahapa. She shares her opinion about these developments. A very good evening to you, Advocate Mahapa, and thank you so much for taking the time to speak to us. I think let's just start with understanding the objection raised on the leaders, evidence leaders, Advocate Mpofu saying that they have no right to cross-examine simply because, unlike the public protector, he says they have no version to assert or test by way of cross-examination. Please explain all of this for us.
Thank you very much, and good evening to our viewers at home. We've actually saw how the matter panned out even previously, relating to the evidence leaders, when the issue of legal costs which were raised that affected or that related to counsels or advocates and attorneys previously, and which caused a serious uproar, and the manner that matter was actually handled, I seem to align with those that were saying that was not done properly or accordingly as their legal ways of which that matter was supposed to have been handled, or else, the evidence leader requests some concern, from the names or the counsels, which names were actually, shared with in the public domain, in terms of, agreeing to the disclosure thereof.
Okay. We'll get to the list of lawyers in just a moment, Advocate Mahapa. Let me just jump in there and interrupt you. If you could just lay out for us laymen who don't understand what Advocate Mpofu is saying in terms of the point that he's making about who's empowered to cross-examine. He mentions the public protector specifically and says, unlike the public protector, the evidence leaders have no version to assert or test. What does he mean by that?
In actual fact, remember that this is an impeachment process. And the challenge is, from the onset, the evidence leader has been said to be, some of the people or one of those that have been saying they really are for impeaching the public protector. And as a result, it seems as if there's some level of biasness. So from the onset, how the public protector's position and Advocate Mpofu's position is that already there's biasness before even the matter starts. And hence I wanted to even come to the issue of that was raised that related to the costs of the legal practitioners. On its own, it seems to be backing up what they have already been saying from the onset, to say, Advocate Mkhwebane has not been treated, accordingly and or fairly, So that on its own poses a very serious, challenge to the proceedings.
Okay, so Advocate Mpofu, just on that point so that we can get past it, does talk about the fact that it was a select group of black counsel who represented the public prosecutor in a variety of matters, and that point made it look like they were looting public funds, or that was the inference of the manner in which they were done. So as you say, that in itself is prejudicial, and this is why there was an apology. But just in terms of prosecutorial conduct, what is expected? So Advocate Mpofu argues that the evidence leaders are discrediting the witness. So I'm sure there are ways of doing things when you are in a particular role. So I want to understand what would be seen as an instrument in terms of pushing to get more information. We'll use, for instance, one of the people that Advocate Mbofu spoke about was when Muntu Sithole was testifying. If we could use that as an example of why evidence leaders are not allowed to cross-examine.
Okay, in terms of cross-examination, right? It's actually a phase that would come after the evidence has been led. So evidence leaders are not supposed to cross-examine because those that are cross-examining are testing the evidence that has been led by the evidence leaders. So you cannot lead evidence and as well cross-examine yourself, you know, because when we cross-examine, we actually test the authenticity of the evidence that has been led.
Okay. Are there fears that this kind of behavior will extend to the suspended public protector, Advocate Mkhwebane, when she faces the hearing? And this is why Advocate Mbofu is pushing so hard.
Come again?
Are there fears that Advocate Mkhwebane could face the same line of questioning? And this is why Advocate Mbofu is pushing so hard to have the evidence leaders recuse themselves.
No, I don't think that is the situation. I think the reason why they're not even requesting that they recuse themselves. In this case, they are requesting them to be removed from
Absolutely.
a matter.
Wrong term, wrong choice of term, yes.
Recuse yourself. Okay, when you recuse yourself, you just step down.
Yes, absolutely.
And when they get removed, that on its own might, you know, extend the period that the process was supposed to take, because then it means a new team must be put in place, and whoever that comes should, you know, acquaint himself or herself with the facts of the case from, you know, inception to date. So that might even prolong the matter, you know, beyond the time that was actually anticipated. So I don't think the issue is the fear that Advocate Mkhwebane might face the same situation. The issue is procedurally, you know, it's not allowed for an evidence leader to cross-examine. So if then, for instance, Advocate Mkhwebane was supposed to lead evidence, what was then supposed to happen is that, and you know, the opponent in this case will be afforded an opportunity to cross-examine the person who has led evidence. In this case, if Advocate Mkhwebane had led evidence.
All right. Thank you so much. Advocate Molatelo Mahapa is a legal expert.